Good afternoon, ladies and gentlemen. My name is Geoffrey Edwards, series moderator and president of the Futsal Association of Trinidad and Tobago. Futsal868 is an online meetup series where global sporting professionals meet. The rescheduled 2021 Summer Olympics, officially the games of the 32nd Olympiad, is scheduled to be held from the 23rd of July to August 2021 in Tokyo. That's just a few days away. With this as our backdrop, Futsal868 Corner Talks has decided to host a four-part series entitled Jeux Olympiques, this being the third of the four-part series. The intellectual property system and trademarks in particular play a pivotal role in safeguarding the unique character of the Olympic Games and their identifications, including the Olympic symbol, Olympic emblems, the flag, the torch, and the anthem. The Olympic Games are the largest and most complex sporting event in the world. The Games are as such a celebration of innovation and creativity as they are of humanity, fair play, and sporting excellence. By protecting its IP, the Olympic movement is able to leverage its reputation and attract commercial partners. Revenue generated by the IOC from corporate sponsorship, from the sale of broadcasting rights, and from licensing not only provides valuable resources for funding the Games, it also contributes to the development of sport and promotes broader humanitarian goals in all corners of the world. Today, in episode 61, we discuss law and the Games. Our guests are Dr. Emma Perot, lecturer at the Faculty of Law, the University of the West Indies, St. Augustine campus. Dr. Perot's expertise is within the field of intellectual property law, with a particular focus on the right of publicity. Joining her is Dr. Justin Koo, Deputy Dean and Lecturer at the Faculty of Law, the University of the West Indies, St. Augustine campus. Dr. Koo is an expert in intellectual property, sports, and entertainment law. We want to say thank you very much, doctors, for joining us and taking the time to be able to spend this evening with us.
Thank you for having us.
Yeah, thanks a lot, Jeff, for inviting me again onto the show.
Obvious that, and I like how you say again, because I want to start with that. Can you give us a recap of, for those who are joining us for the first time, and those who may have seen you last December, can you give us a recap introduction of intellectual property?
Well, actually, I'll ask my colleague, Dr. Perot, to just do a brief overview of the areas of IP that are relevant to sport, and then I will tack back in at the end just to add on to that. So,
most definitely.
Perot.
Okay, sure. So intellectual property is a very broad area of law with many different categories. I'm going to focus on the ones most relevant to sport. So to start off with, intellectual property protects non-tangible assets. When we're thinking about intellectual property and sport, one of the first things we can think about is copyright. So copyright, for example, in the drawings associated with certain events, the logos, anything that might be considered a literary, dramatic, musical, artistic work, photographs taken at the events. We then have trademarks. So while copyright is relevant to the logos, trademarks can also be relevant. Within trademarks, there is the unregistered and registered trademark law. So registered trademark law is when you go to your National Intellectual Property Office, you register your mark or word or slogan, as the case may be, and that gives you protection against confusing uses of the mark. We also have unregistered trademark law, which is known as passing off, but it is a lot more difficult to bring a claim in passing off because the requirements are a bit more onerous as compared to when you have a registered trademark. In terms of trademarks and sport, as we're thinking about the Olympics today, things like the Olympic rings, the name of the Olympic Games, all these things would be protected by trademark legislation that had to be introduced for the Olympics, and also other general trademark legislation. Athletes might also choose to trademark their names or even certain sayings that they can then use to promote themselves and to produce merchandise. We also have persona rights, which is my area of expertise. It's known as different things in different countries. So in the US, you might talk about the right of publicity, the thought of appropriation of personality in Canada. Unregistered trademark law also becomes relevant in this area. But no matter which terminology we're using, we're thinking about the protection of your name, voice, image, personal likeness, and other features against unauthorized commercialization. So when we think about persona rights and sport, we're thinking about athletes entering into endorsement deals and being paid to make this association with a brand, make this connection. Patents might also be of relevant to sports, but it would really more be on the side of companies that produce equipment, for example. So let's say they create an improved tennis racket. If they can meet certain criteria to get a patent, so it has to be novel, inventive, non-obvious, have industrial application, and meet all these criteria, which are actually very difficult to meet, then they can get a patent, which will prevent others from making their same invention. So I would say trademarks, copyright, persona rights, and to an extent, patents are the most relevant areas of IP when it comes to sports.
Thank you very much for that introduction. Dr. Koo?
Yeah, just to add to what Dr. Perot said, I think we really have to reiterate the concept that without intellectual property, sports does not operate in the way that we understand sports today. And I really want to make emphasis or draw reference to the impact of broadcasting on sports, and in particular, the impact of broadcasting on the Olympics. The Olympics, as we know it today, only really exists because of the influence of broadcasting and the ability of the Olympic Committee to really harness and leverage the money and the financing received from broadcasting in order to make the games into the standard and the stage that we know it today. So the big, opening ceremony, having all of this sort of fanfare attached to the Olympics and any other mega sporting event is really due to the fact that because it's being broadcasted, these things are being done. The enhanced welcome segment where you have all the teams parading, that sort of thing. You might have a performance by a popular artist or something like that. This is all the show that is being put on because it's being broadcasted. If it wasn't being broadcasted, these things don't exist. In order to have that broadcast exclusivity, that's where copyright law steps in. So while sports in itself is not subject to intellectual property protection, so for example, one cannot copyright or trademark or patent a guy or a girl kicking a ball on a field into a goal, or running a 100-meter race, or doing the long jump, or any sort of event like that. There's no IP protection in those things. Where someone does actually record that performance and then subsequently broadcast it, that is subject to copyright protection. So the actual broadcasting of the events that take place, that is subject to copyright protection. That is where all the value in sports is. So the reality is that without copyright law and without allowing the IOC or FIFA or the English Premier League or whatever the case is, from taking those broadcasts and being able to commercialize it, there would be no value in sports. There would be no money attached. And all of the money then flows downward from the broadcasting into the other things like the branding of the event, the branding of the athletes, the branding of the sponsors that are attached, and those sorts of things. So, like I said, without IP, sports as we know it today doesn't exist.
It's really that interesting that you mentioned that, because the Olympic symbol Yeah, we back. Yes. So technology as its greatest. So I was speaking as regards to the fact that the Olympic symbol of the 5 interconnected rings, known as the Olympic rings, is one of the most recognizable global symbols. And you speak about protection. In our research, we came across something known as the Nairobi Treaty on the protection of the Olympic symbol. Can you speak more to that, as well as who is this WIPO? Where do they exist? How do they come about? How do they protect mega events such as the Olympics?
Right. Okay. So let me start off the discussion, and I could turn it over to Dr. Perot with a little more general discussion about trademarking in the Olympic signals or symbols, that are then used to signal, well, this is connected with the Olympic Games. So in terms of the Olympics in particular, there are many sorts of signs, because in trademark law we talk about signs or devices. There are many trademark signs that are relevant to the Olympics. So the most famous one is the interconnected rings, of which there are different colors. Yeah, and everyone associates. Once you see the rings, you know we're talking about the Olympics. That is given special protection. So yes, there is the Nairobi Treaty, but there's also domestic law which allows for the documentation that look, these particular signs or symbols are protected because of their one value to the Olympics, and two, the fact that if they allow people to start using these things, then it waters down or it dilutes the value of the brand of the Olympics. So we want to ensure that when you see the Olympic rings, you only assume or you only know that this is associated with the official Olympics. And we've seen this in other brands where brands get watered down or diluted because any and everyone can use it. So this is the real value of having a trademark. But what I want to add to this discussion, it's not just the Olympic rings that we're talking about. We're talking about protection being afforded, whether directly through trademark law or through something analogous to trademark law, where you have domestic legislation, which Dr. Perot will talk to soon. Things like gold medal, silver medal, bronze medal. You have the name of the game, so the word Olympics, Olympic Games, the torch, the symbol of the torch. You have the host name. So, for example, Tokyo 2020. That would be subject to trademark protection taken as a whole, even though ordinarily this would not get trademark protection. So I don't know if Dr. Perot wants to add a little bit to that discussion.
Sure. So in terms of protecting the rings and anything associated with the Olympics, it does depend on which country you're in, but generally speaking, because they're well-known marks, they will receive a strong level of protection. So there is a provision in most countries that protects something known as well-known or famous marks. And it's not just for the Olympics. It will be brands like Nike, Apple, mega brands that everybody basically knows about, even if you cannot necessarily access the product in your country at this time. They're brands that everybody just knows about either through their marketing, their presence on popular media, the popularity of their goods and services, etc. Even in the Trinidad Trademark Act, which was updated in 2015, there is this provision that you can protect these well-known brands. And these well-known brands aren't only protected against confusion. Of course, it depends on your legislation, but they can also be protected against uses that might harm the reputation or just make the reputation less distinctive. So the Olympics would fall within this category in terms of the rings and, of course, the word Olympics. In addition to that, there is sometimes specific legislation in certain countries. So, for example, in the US, there is legislation in place that allows the National Olympics Committee in the US to bring actions against anyone who uses the word Olympics or anything that can be associated with the Olympics in any year. So not just limited to, the Olympics in this year. If there's, for the next Olympics, this act still applies. It doesn't have to change because it has longevity in that sense. And they can bring a claim in court similar to how they would bring a trademark claim. So that's very specific legislation that gives all the Olympic words and symbols very strong protection. And then, of course, if you are hosting the Olympics, then you are required as a host country to implement legislation specifically protecting everything to do with the Olympics. And that legislation is going to be very broad. It will have a sunset clause, so it will come to an end at a certain time, but you will be required to do everything to protect the value of these symbols or names. So whether it is the host country with their legislation, which is required, whether it's another country that has opted to have legislation specifically for the Olympics, even if they are not the host at this time, or whether you go through the well-known marks provision, which is present in many countries, there are lots of different avenues that can be used to protect the Olympics as the name, as well as the rings and anything that can be strongly associated with the Olympics.
Do you know of any national organization within the Caribbean that actually have protected their intellectual property in this regard? Noting especially like Jamaica, where that Jamaican brand, first and foremost, the Jamaica brand, the Jamaican identity, as well as the Jamaican track and field image that is, I would assume that they would have done something to protect their own. Is that the case, or any other Caribbean National Olympic Committee?
Well, in terms of protecting their own national brands, they wouldn't necessarily be able to make an associate. So The Olympic Committee can't protect the Olympics, yes, in terms of the word, the symbols and whatnot, but in terms of protecting their national status, that is slightly different because they cannot treat it as, even though it's connected, they cannot treat it as one. So while the National Olympics Committee will have certain authorizations in terms of how they can make associations, in terms of protecting their national brands, they can go on to register trademarks in different jurisdictions, but it would depend on what exactly they want to register it for. So do they want to register it for example, sporting equipment, clothing, merchandise, and then those types of marks, well, all marks are jurisdictional. Those ones would be as well, whereas the Olympics is really much broader and really is property of the International Olympic Committee with certain permissions given to each national organization. I have looked at Trinidad. I was going to our legislation. I haven't seen anything in our legislation based on my look so far that actually extends specific protection to the Olympic marks, even though we do have an act that incorporated the National Olympics Committee. But that being said, we do have the famous mark protection that can be used in our Trademark Act. Justin, I don't know if you want to add to that?
Yeah, so I think the issue that you have to deal with here is sort of the fact that because of the status and the nature of the Olympics and the International Olympic Committee, they are afforded certain privileges by being an international organization. So they get sort of, let's say, global protection, whether they choose to protect it by trademark law or not. Whether it's through a treaty or through the use of different treaties, like the Paris Convention that affords that famous brand protection on an international basis in each individual country that is signatory to the Paris Convention. So you'd find that almost all of the countries that we're talking about are signatory to that Paris Convention, which really protects industrial elements of IP. So we're talking patents, we're talking industrial designs, we're talking trademarks. So you get that sort of protection, but then it's up now to the individual National Olympic Committee to decide whether they want to protect their branding. And again, as Dr. Perot said, it's really what do they want to use that branding to do. If it's just for the sake of the support of the national athletes, then it may not necessarily be so important to them to commercialize it, because they're not necessarily going to say, look, we're going to leverage this to make commercial revenue. But if it's the case that they want to start, raising fundraising to send athletes off, because we know sometimes it's very difficult for athletes to get funding to actually go to the games. And we're not just talking to the Olympics, we're talking for them to compete on a yearly or annual basis, yeah? Then they can, register that trademark, but they have to be very specific as to what they're registering it for. As Dr. Perot said, is it for merchandising? Is it for equipment? Is it for services levied? That sort of thing. So it's very much up to them. I am not 100% sure if we have any that in the Caribbean that are represented, but I will not be surprised if the TTOC in Trinidad has it sorted, and in Jamaica at least. I can speak to those two because obviously they are well represented on the international stage. They have the financing to do these sort of things. Where you'd find difficulties is where you have some of the smaller territories that may not have the financial resources to embark in a trademarking process for their branding. And the real issue here is that a lot of the money may be spent on administration, and a lot of the money may be spent on actually helping the athletes. It's not a cheap process to sort of get into trademarking your brands, especially where you're not sure what the commercial value of trademarking it is. And this is something I think as a region, and not just in relation to Olympic committees or in relation to athletics, but across the board, sporting initiatives need to take greater stock of the value of IP and how they can harness IP and leverage IP to create additional revenue streams, such as seeking sponsorship for their athletes or seeking sponsorship for their teams or for their sporting events. So I think this is where the role of IP and sports definitely intersects.
And it's interesting that you mentioned that, because based on our research, and I'm just going to put it up on the screen here,
sure,
that in terms of sources of income for the IOC, sale of broadcasting rights, Dr. Koo, for which you mentioned in the beginning, represented 47% of income. Sponsorship agreements represented 45%. Licensing agreements represented 3%, and ticketing represented 5%. Just to note that this source came from the Olympic Marketing Fact Sheet 2018 edition. Now, 47, 45, 3, 5. How does intellectual property fit into the chunk of that? and break it down in layman's term for persons, because some persons might be like, this boring. How does we dealt with transgender last week and intersex. We dealt with Rule 50 the week before. We go and deal with anti-doping next week. But a lot of persons don't understand, how does IP, intellectual property, the law of the games, actually make the games run? Share with us.
Okay. So based on those figures, 95% of the income is IP generated income for the Olympics. That 5% that is ticketing, that is really the only money that's being made from people actually going to the Olympics. But the rest, so sponsorship is going to be involved in IP. So when we got into Rule 40 and the restrictions on sponsorship, we'll see that actually being able to say you are an Olympic partner is a very prestigious, very expensive deal that you are entering into as a sponsor. And it's also a right that is very strongly protected. So all that sponsorship money is really about being able to use the IP of the Olympics, namely the rings, to be able to even say the word Olympics in relation to some kind of commercial activity, any special marks, for example, the Tokyo 2020 mark. All that is the sponsorship. In terms of the broadcast, as Justin mentioned earlier, the broadcast rights really is allowing us people at home to be able to watch the Olympics. But it's not just that we're sitting down and watching it, it's that the ads are playing in between. And it's not just going to be the sponsors who have the ads, because you might have ads that are not at all related to the Olympics, because they can't be unless they've been paid. They paid for that privilege. But you can have ads that aren't at all related and are still playing on that airtime, generating revenue, making those broadcast rights very valuable, especially as the Olympics is viewed all over the world and is extremely high in viewership. And then even that small licensing figure that we saw, which I think was maybe something like 3%, most likely they are licensing for the production of different products and whatnot. And that is still going to involve some type of intellectual property, whether it is copyright, for example, in licensing the ability to print certain brochures, whether you're creating little teddy bears or anything like that, you're still going to have IP coming in. So based on that breakdown, we have 95% of that money is all IP backed.
So people don't think this is boring. This is what is driving the Olympics. And as I said before in my opening, 90% of the revenue generated goes back into humanitarian efforts and development of sport globally, every corner of on the earth. So I want to say thank you very much for that explanation, because it really and truly was very much interesting to me to be able to understand, how does IP drive the Olympics. Let's talk ambush marketing. So I'm excited. I see Trinidad and Tobago do extremely well. And I decide to go on my social media platform, Futsal868, and big up Team TTO. Hashtag, etc. Hashtag this, hashtag that, hashtag the other. Boom. I want to see if I wreck the internet and I get 20,000 views for this one video I put up. Is that ambush marketing? What is ambush marketing?
Right. Okay. So let's deal with the definition of what ambush marketing is to begin with. So to be considered ambush marketing, you have a situation where you have a commercial entity, because ambush marketing does not address non-commercial use. So you have to talk about a commercial entity that is engaging in some sort of advertisement that associates themselves, i.e. the advertiser, with whatever event we're talking about. So if we're talking ambush marketing in the context of the Olympics, it's the idea that a particular brand or particular company is trying to associate itself with the Olympics for the purpose of making some sort of gain, whether that's gaining followers, gaining prospective customers, gaining actual revenue. So it's only going to be considered ambush marketing where you do not have permission to do that and you're doing it to gain some sort of commercial element, or there's some revenue aspect attached to it down the line. So what you'd often see being called ambush marketing is where you have, all right, so we all know that, for example, with the Olympics, there are tons of title sponsors. What you would find then is that in each individual element of the title sponsor, so let's say it's Coca-Cola, right? For example, if Coca-Cola is a title sponsor of the Olympics, Pepsi is not going to get any sort of title sponsoring element, because part of the deal is about exclusivity. if one major category, so soft drinks, food and beverage, if you want to call it that, you will see that there are limited entities engaged that are official sponsors. The Olympic sort of agreement is that we won't have multiple sponsors in the same category. And then what's the point of offering the exclusivity if any band jack can buy into it? Yeah. So what you might find Pepsi doing is that, look, I don't want to fork out the $200 million plus to be an official sponsor. That's how much we're talking about to be an official sponsor. 200 million plus. And that's just for the 4-year period of the whatever games we're talking about, whether it's the World Cup, the Olympics, etc. So a company might say, look, I don't want to spend $200 million to do this. So what I'm going to do instead is, just do a regular advertising campaign and try and get as close as possible to the games that, makes people think that I am somehow associated with the games. So we've seen many companies run all sorts of different types of ads or ad campaigns that, have sort of try to break the internet. So I'll make mention to one that took place, I believe it was in South Africa during the World Cup, where a competing alcoholic beer sponsor actually sent fans into the stadium dressed in a very particular color. It was orange, which was a sort of competing color to, I believe it was Budweiser's red. And, it made news because they all got arrested when they refused to leave the stadium, because on the back of your ticket has clear wording about ambush marketing. We see it in the NBA all the time. If, let's say, Adidas is the title sponsor of the NBA, if you go into an NBA game and you're wearing a Nike jersey, you often see people in the stands with these massive T-shirts covering whatever clothing they're wearing. It's because they're wearing a competing brand at the event. That's how far these entities go to protect against ambush marketing. Because if ambush marketing takes place, the exclusivity of the deal with potential sponsors then disappears, and then no one wants to pay the massive sum to get that exclusivity. So maintaining exclusivity is sort of the point of having rules or regulations against ambush marketing. But ambush marketing sort of is controversial because one of the sort of breadth and the scope of the rules that we see in particular with the Olympics, and we'll talk a little bit about Rule 40 in a little bit. But I don't want to get too much into that discussion because I think understanding the sort of the actuality of what amounts to ambush marketing is critical. So it's where you are not aligned or not an official title sponsor, official affiliate of an event, and you are then advertising in relation to that event. So there's a really brilliant ad for Nike, which was in the run-up to the Olympics in Great Britain, where they made reference to multiple places around the world called London. And they had persons, doing all sorts of amateur sports, which would have taken place at the Olympics. But they did it in a sort of smart, snarky way where they were saying, look, I'm going to, be in your face about it, but I'm not talking. And they made express mention that say, I'm not talking about the London Games that's taking place in the summer. I'm talking about, Londonderry. I'm talking about London in some backwater place somewhere that, there's a little sign named London, for example. So they always have to do it in smart ways. Gambling sponsors are always a big deal as well. So we've seen this in football with, one-time controversial footballer, Nicholas Bentner, where the sponsor for him was Paddy Power, I believe it was. That was the official gambling sponsor of the tournament. But what did he do? He had on an underwear, and the underwear band, so where the elastic band is, had paddypower.com written on it. So when he scored a goal, he kind of just lowered his pants a little bit and he saw the waistband. Or I guess at intervals, he would kind of fix his pants or something like that, and you'd see the band flash on the screen. So those are the kind of things we talk about ambush marketing. But to give you the best Olympic example, I can't remember the athlete off the top of my head right now, but the official sponsor at that time was Reebok. And he went to the press conference. He couldn't wear any of his Reebok gear at the press conference. What did he do? He put on contact lenses with a Puma on it because Puma was his sponsor. So to get around all the Rule 40 rules, get around ambush marketing rules, he put on contacts. So when they zoomed up on his face and they took all the pictures of him, all of the marketing materials that came out of that interview had Puma in it, despite the fact that Puma paid $0 to the Olympics to advertise. And they got the benefit of millions of people following.
I was very impressed with what Beats by Dre did. You remember that?
So that's a really good example.
Exactly.
And I think one thing to note is that ambush marketing is really kind of on the borderline as to what is not permitted. So ambush marketing is not what we talk about when you do things that are strictly prohibited. It's really that you're trying to get around the rules and draw an association in a way that does not actually breach the rules, but it might seem like it comes very, very close, which is why people seem to be very innovative when it comes to ambush marketing. So I can't remember which Olympics, but it was not too far long ago. It was one of the Olympics where you saw the swimmers had on the Beats by Dre headphones. You saw Team Great Britain had their customized Beats by Dre headphones, and they were not an official sponsor. But of course, when the camera is on these people and they're getting ready to run their race or swim, it's very attractive because you're seeing the headphones standing out. So they gave these athletes these headphones, and strictly speaking, there was nothing stopping the athletes from wearing them because it is just their personal listening equipment. Where the athletes and the brand did get in a bit of trouble is when they tweeted, for example, thank you messages. They did have to remove that. But the actual wearing of the headphones was a great example of ambush marketing because it was just a personal piece of equipment that they were listening to their music. So it could have come across as not exactly breaching the rules. This is why ambush marketing is really a gray area, and you have to be very, very, I think, smart when you're thinking about what can I actually get away with if I'm trying an ambush marketing campaign.
Not to drift too far, but let's speak about the tools of the trade, as is known in law, that can be used for ambush marketing. Dr. Cook, can you speak to that as well, please?
When you say tools of the trade, you may give some both clarification.
So like in football, the boots, football boots.
Right, okay, got you, okay, correct. Yeah. So this is the thing. In order to what they would tend to do is you'd see players do it in football in particular, where they have things, and I'll make a sort of diversion here, which is related, and it's sort of similar rules where in football, under FIFA rules, you're not allowed to have political messaging or anything that is going to be perceived as sort of conflicting with religion, gender, or anything like that, right? So, for example, when Pep Guardiola wore the ribbon to support the Catalan independence, he got fined every week for wearing this in his tenure at Man City, right? The Barcelona players also, some of them had support for Catalonia in that way, and they were all fined. Right, but what you'd see players do in terms of getting around the advertising requirements, as I said with Nicholas Bentner, wearing articles of clothing that aren't, considered part of your uniform, because there are laws under the FIFA laws of the game, for talking strictly football, that require certain things to be done. So, for example, with your socks, if you're wearing tape around your socks, it has to match the color of the socks. Yeah. In terms of your undergarments, it must be in line with the color of your shirt. So if I'm wearing a blue Chelsea shirt, if I'm wearing, let's say, a rash, what we call a rash guard underneath, or thermal wear, etc., it would have to be blue. You would see that maybe underneath their shirts as well, they would have messages. Not sometimes just happy birthday, but other times advertising or making a political statement and things like that. So you have to do it in a smart way. You'd see messages written on people's boots. You'd see things on their shin guards. So, for example, they're taking a free kick, they'd roll down their socks, you'd see the front of the shin guard. And that's where, as Dr. Perot said, you have to be smart in using the tools of the trade to make advertisement. In football, or, during your running your race in the Olympics, that kind of thing, you can't run with the headphones on. But you know that if you're a popular athlete, chances are the camera is going to be on you in the warm-up. So you take advantage of the period before the game, after the game, at halftime, that kind of thing. Or if you're on the bench, you take advantage of that to try and make an advertisement. And the thing is, the rules aren't necessarily clear because, of course, if you're wearing your headphones before, no one's going to say, well, you can't do that. What they might make you do, if it becomes too much of a problem, is what we call blacking out certain things. So you'd find that in the NBA in particular, this is an issue where sometimes, a player shaves a sign of their sponsor on the side of their head, and then sometimes they make them, because if the sponsor complains before the game, they're going to have to take a clean shave and get rid of that. Where you have competing sponsors as well, you sometimes find, equipment being blacked out. And this is actually a sort of double-edged sword, because where an athlete does not have an exclusive sponsorship, they black out all of their gear. So there's no branding on any of their gear, because the whole point is to try and attract a sponsor to take you on and give you money to wear their stuff. So you'd see blacked out boots. In cricket, you'd see players taking all the labels off of their batting gear, spray painting their cricket pads and stuff like that. So ambush marketing ties in with the sort of personal value an athlete has. So yes, there are rules that the governing body sets, which dictates again about exclusivity with the deals that they have. But at the same time, there's a huge player element here that must be factored in as well. So Dr. Perot could add in here as contribute to this discussion.
Yes, I think it's also worth noting that because people do find very innovative ways to skirt around these rules, rules will be updated for different events going forward. So once they realize, okay, somebody has done this, they will try to update the rules for the next event going forward to avoid that. But people, of course, are very innovative. It might not be that they're even advertising through an athlete. It might be that they're creating some type of association in the way that Nike did by saying, every other London and not those games. So people will find ways to try and skirt around it. Now, it could be sometimes that ambush marketing actually would fall foul of the rules, and then it's at the discretion of the National Olympics Committee if they want to pursue a legal claim. And Nike's own did come, I think, very close because they used London extensively. And even though they didn't make direct reference to the Olympics, it's like they nearly specifically said not that to make people's minds think about it. So I think that would have been an interesting case. The London Olympics Committee did not decide to pursue it, but it is really a very borderline type of advertising that might or might not fall foul of the rules, but you're trying to, I guess, not get sued. That being said, there are some brands that don't really mind being sued. Paddy Power is one of them. They are actually notorious for ambush marketing. They are always doing things against whichever regulations are in place, whichever sporting event, but they obviously have a litigation budget where they know they'll make more money than they're going to spend anyway.
That's super interesting. That's very interesting. So we're going to take a quick break, guys, and when we come back, we're going to speak Rule 40, the Olympics license program, and the IP journey of the Olympic Games. You're watching Futsal868 Corner Talks, episode 61, the law and the Olympics. We'll be right back. With tomorrow being the reopening of sport, more so non-contact sport, whereby groups of 5 could go back to exercise, we are going to continue our virtual race challenge. So just to remind you, just take a quick look. So yes, we ask you to join our friend Bob along with myself. The race is virtual, but the sweat is real. So please, as you know, the doors open tomorrow. Let's continue to be able to relieve some stress, get out there in the fresh air, and be able to do it for a cause. So we're back with Futsal868 Corner Talks as we speak the law and the Olympics. And as we said before we left, we want to speak to Rule 40. We started off Jeux Olympiques with Rule 50. Now we are speaking about Rule 40. This IOC and all of their charters, man. Come on. But Doc, let's hear what is Rule 40 as regards intellectual property.
Okay, so Rule 40 is something very interesting to speak about because of the changes that have been made to it. So in the past, Rule 40, which is the rule that protects intellectual property surrounding the Olympics, essentially prohibited non-Olympic partners from using any images of athletes during the blackout period, which would be about 10 days before, as well as duration, and 3 days after the Olympics. It was very, very strict, and that was to prevent any type of association being made with the Olympics. So, of course, you cannot make an association in general, but even if you had pre-existing deals with an athlete who happens to be competing in the Olympics, you are not allowed really to use anything relating to that athlete during the blackout period. Now, Rule 40 has been somewhat relaxed for this Olympics this year, which was meant to be last year, of course, in that the rules have been altered so that the athlete gets some type of leeway, as do their non-Olympic partner sponsors. However, the rules are still very strict. In terms of what the athlete can do, the athlete can send a thank you message. They can post this on social media during the former blackout period. But they cannot say that their sponsor's product has enhanced their performance. They cannot draw any kind of reference to the Olympics if they're thanking a sponsor. And they also cannot basically do anything that would endorse the sponsor, apart from really just saying, thank you for your support. So something very basic. They also cannot even post a photograph of themselves receiving a medal, because that would be considered as drawing a connection with the Olympics. As to what the non-Olympic partner sponsors, and when I say non-Olympic partners, I mean they are not official Olympic sponsors, but they are the sponsors of the athletes. What they can do is very strictly limited. They can have so-called generic advertising, so they can have ads that would feature their sponsored athlete if it meets certain conditions. It must have been running at least 90 days before the blackout period. You cannot increase the frequency of the ads during the blackout period, and the ad itself cannot draw any type of association to the Olympics. So you should not be even having a background of somewhere in Tokyo. You should not be putting the rings in any form, whether you're drawing a reference to it or using the actual rings. You cannot say Olympics. If your person was a past Olympic athlete, you can mention that performance as long as you are not highlighting it more prominently than their other athletic achievements. So it's actually very strict. And you also cannot, during the blackout period, congratulate them in a way that is connected to the Olympics, and you cannot retweet their thank you messages during the blackout period. So while Rule 40 has been relaxed, it's been relaxed in a very minor way. So there are certain allowances that have been given compared to the total restriction that was previously in place, but it's still a very, very strict approach. And it's really athletes who could potentially suffer if the restrictions are broken, but the brands can also be pursued through the various trademark avenues that we had previously discussed.
I am trying to choose my words wisely, but that's rough, boy.
It's very strict, and anybody who's interested, I recommend looking at the Olympic website, because they do have a guide for non-Olympic partners, and they give you lots of different little illustrations of ads, and they tell you exactly what's wrong on each one. And literally there's one of them where there's a runner running on a road and Mount Fuji's in the background. That's too close to the Olympics in terms of evoking Tokyo, so that would not be allowed, even though you haven't said anything otherwise. You also cannot say, for example, road to Tokyo, or anything that indicates that you are somehow supporting this athlete in connection to the Olympics. You can support them otherwise, but nothing close to the Olympics.
Not trying to sound too harsh or hard on my Caribbean sports and media outlets, formal and informal, but I could see many of them preaching these acts given the fact of not knowing because of lack of knowledge, man shall perish. And I really appreciate the work that you both are doing. And I humbly ask that you try during the Olympic period to ramp up public knowledge because, again, I'm saying there's one particular media house, social media house, that I know that it's extremely popular. They have over 20,000 followers on Instagram alone. And it will be, I know that some mistakes may be made. And given the fact that, they are a voice to athletes, they are a voice to individuals, it's just fine trying to make sure that we learn and we do the right things. So I want to say thank you very much for Dr. Perot because I know line to tell you. We too at Futsal868 looking for a little new followers. So, we were going to probably try to see if it is we could have pick it back on. But now we learn. We can't do such. So, moving on to the Olympic licensing program. What is that? What is the Olympic licensing program?
Right. Okay. So when we talk about licensing program, it's again, it's just about licensing your intellectual property. So the Olympics has multiple things that they own as intellectual property. So we could be talking about the Olympic rings again. We could talk about the name Olympics, Tokyo 2020, anything like that. But there's also other elements of licensing that I don't think people pay enough attention to. So the merchandise. Let's talk merchandise because this is really critical. And I want to make a broader statement outside the scope of the Olympics. It does apply here as well, but and this is really directed at our Caribbean entities that are involved in sports. The money in sports is not just about the revenue that you get from ticket sales. It's not just the revenue that you may earn or get sort of through charity or through sponsorships, but it's also about products for sale. So when you have a licensing agreement, it is the idea that you are permitting someone in exchange for remuneration, whether it's money or otherwise, to produce some sort of license goods. So the license here would be about the mascot. So for example, every Olympic Games, there's a special mascot and there's stuffed toys made, there's stickers, etc. It could be to make a sticker book, about the Olympics, which would have all the athletes and the different sporting fields and things like that. It could be the licensing about the broadcasting rights. So the license is really key. And again, you have to understand what you're going to get in exchange for paying money. So of course, we know about the title sponsor licenses. We know about the broadcasting licenses. But beyond that, it's really about thinking about, and I call this other ways, alternative revenue production streams. How else can you generate revenue? And this is where, again, where, sort of IP steps in to say, well, it's not just about kicking a ball, or it's not just about running on a track, it's not just about jumping over a pole, but you know what, there's actually a whole lot of commercial elements involved here that we may not take seriously that does contribute. So I think on this slide that you put up, there was a 3% sort of contribution to the overall Olympic revenue generator in relation to licensing. But from a more localized perspective, if, we're talking Futsal868, for example, you could think about producing jerseys, you could think about producing stationery, mugs, plates, hats, anything like that. And it's about raising brand awareness, getting your fans, getting your customers to connect with the brand. And also it's a free form of advertising because every time somebody wears that Futsal868 shirt down the road or you wear an Olympics t-shirt, people say, oh, did you go to the Olympics? And then a whole discussion about the Olympics grows, and that's free advertising. So the licensing program is really, really critical in terms of taking the word about whatever event we're talking about to the next stage, to the next level, keeping the talk consistently going.
I think it's also worth saying that even though the licensing accounted for 3%, the sponsorship and broadcast rights are all done under licenses because a license is essentially permission to do something that you otherwise would not be able to do. So the licensing that we just discussed is really in relation to merchandising and whatnot, but sponsorship is done under license, as is broadcasting. So all these are just different types of licensing deals.
Really interesting stuff. So let's talk about the IP journey of the Olympic Games. How soon does intellectual property begin, and when does it end? When you talk about this journey,
Okay, so the journey begins quite early on. It begins in the bidding process where the cities that want to host the Olympics have to start putting together their bids. So their bids will include things like what type of cultural activities they will be doing around the games, how they plan to meet their infrastructure needs, their accommodation needs, all the physical aspects of the games. But cities will also start doing things like registering their city names in connection with certain sporting categories. So sporting events, sporting equipment, merchandise. So obviously they cannot actually register it in connection with the Olympics at this point, but they can register their own city names. They can also do, yeah.
So, sorry to cut you. You know, I know it's a little unmannerly, but sorry to cut you. But that's really interesting because if 5 cities are going up for the Olympic Games and only one gets it, the other 4 has spent all this money for intellectual property.
Yes, so the Olympic bids are actually very expensive because in addition to that, so they might start registering stuff, but they will also start taking domain names. And when we say domain names, we're talking about website names. The reason they'll do that very early is because if they do succeed, they don't want anybody else to buy that up and then they have to buy it off somebody else. So, for example, anything connected to the Olympics, they will just start registering and you have to pay for that. That also has a trademark element in it if there's a dispute, but it's easier if you just start buying all the domain names to avoid any issue down the line. And then you can add that to your IP portfolio. So when you go to create your bid, you already have an IP portfolio that you have started to build. You might even be starting to think about branding. What type of logo would you want to be doing? And while we did mention that, of course, the Olympic logos and whatnot have trademark protection, even the creation of the logo involves copyright law. So you are paying people to generate this portfolio of IP, and you don't even know if you're going to get the bid. But because the Olympics really does want a very strong level of protection from the get-go, it can make your bid attractive, and perhaps it can be detrimental if you haven't really proven that you are taking serious steps to protect your IP, because the Olympics committee is so serious about it. You need to match their attitude towards your protection as well. And that's just the first part.
Please do continue. That's
right. So if you actually get the bid, keeping in mind that you're not going to be the only ones, you might not get it. If you do actually get it, then you have to start moving in earnest. So you're doing all your infrastructure, you're building stadiums if necessary, you're building accommodation, Olympic Village, all that stuff. But you are also then further expanding your IP, and not only by registering and creating, you have to introduce the relevant laws that the Olympics Committee will give you guidance on to protect what you have already created and what you will be creating for the Olympics. So all the logos, any type of variation of mascot, if you have a specific tagline you might be using, anything that might draw attention and attraction to the Olympics, you have to start putting the law in place to make sure you have the strongest protection possible as the host country. So you're continuing to build your portfolio by, enhancing the logos. Maybe you're doing different designs. Maybe you're starting to make plans for your merchandising. Like, what exactly are you going to be doing with all this? You're going to start thinking about your packages as well. So obviously, if you are a sponsor, you want to know exactly what you're getting and how much you have to pay for it, which means when you have this IP, you don't just let it sit there. You start thinking strategically, all right, how much am I going to charge this headline sponsor? How many sponsors should we be allowing? Which are the categories that we will allow? Which categories would be prohibited? So you have your portfolio and you're building infrastructure around that portfolio to use it. And then we come to the actual Olympics. So you've done the legwork before you even got through. Once you get through, you start putting the law in place and you continue to build and you create that infrastructure. Now all the infrastructure is in place and you're coming up to the actual Olympics, and you're going to have to really be policing everything that you've worked so hard to create. So you want to get the benefit of the licensing deals you entered into. You want to be making sure that you are promoting your sponsors, that your sponsors feel that they're getting their value for their money. So you want to be addressing things, giving very clear guidelines to the athletes, giving clear guidelines as to what non-partners can do, as is available on the Olympics website. So it's really about this process from starting from the very bottom, having a lot of stuff in place before you even start. And then when you actually have the games, you have built up this portfolio, which probably would have taken a good 10 years of legwork before. to have this very, very valuable set of IP that generates the 95% of revenue that we saw when you had pulled up those statistics.
That is, wow, that's a lot of work.
That's it
definitely is.
And that's part of it, and that's only half of it, because that was what, 43% of it. The other 45% of the discussion is it broadcasting.
Yes,
so when we host
and that's when it actually starts.
Yeah, and that's the real thing, right? So the broadcasting here, so that the sponsorship only exists where you have the IP in place. So you have we're talking Tokyo 2020, we're talking the Olympic rings, which already exist, the mascot, all of those things. So your trademarks in particular, but the copyright also accounts for 45%, as we discussed, and this is where the broadcasting comes in. So when the host city is awarded the contract to host the games, they then start talking to broadcasters. So traditionally, and we're talking way back when the Olympics weren't being broadcasted internationally, you may have only seen the games within the country that the games actually took place. And then it started to grow regionally. So then we're talking, like I believe the Germany games, and I think that was in 36, was broadcasted across some portion of Central Europe and maybe the UK. And then we started looking to see global growth of it. So the games in 84 in Los Angeles really changed the market. And that's when we started seeing the mega event that is the Olympics today. And that's because of broadcasting. So the broadcast revenue initially, the Olympic Committee probably got somewhere between, I just watched a documentary thing and it said 1 to 4% at the beginning. And then it steadily grew up until it was about, let's say, 25, 30%. And now at current, the Olympic Committee gets about 73% roughly of the broadcasting revenue that is generated. So the host country or the host nation only gets about 20-something odd percent of the value of that broadcast. So this is where the Olympic Committee gets that large portion of their money from. And the broadcasting rights are subject to copyright. Because as I said, you cannot copyright the actual playing of a sport. But what you can get copyright in is the recording or the broadcast of that sport. So when it is when it's transmitted live on air, any subsequent reuse of that broadcast is controlled by the IOC. You cannot repost a clip of the events. You cannot broadcast it on TV without permission of the Olympic Committee. And if you do, you're going to get it taken down. And we've seen this many times in other sports online where you're trying to access an illegal stream and it says this has been taken down due to a copyright infringement or a copyright notice, for example. Even if you're posting pictures that came from those broadcasts, that is likely to be taken down on social media. And this brings in a whole other discussion of the copyright works that are held by the Olympic Committee. So you will see in 2 weeks' time, when the first podium ceremonies take place, persons posting lots of pictures of the athletes on the podium. And those pictures will be the copyright of either the IOC directly or an individual photographer or an individual photography association. And we might be talking news associations like Reuters, or we might be talking an institute like Getty Images or something that may have copyright licenses in place to deal with these things. So you cannot, as an individual, whether you're the consumer at home, the watcher of the TV, or whether we're talking the athlete, you can't just take up a clip of yourself running a race and say, hey, look, I won the race. Here, see me running the race. You can't do that because of, again, the strict rules on broadcasting and control of the copyright works involved with the game. So this is really the crux of the value here between the trademarks and the copyright. This is how the Olympics makes all of that money, which is then reinvested into the Olympic program to help, whether it's humanitarian needs or it's to help, the refugee athletes train, and to even just help out some of the smaller countries actually get their athletes to the Olympics.
Very interesting. It is estimated that the Tokyo Games will generate around 9,000 hours of content over the course of 17 days, an increase of 30% on the Rio Games. The Olympic Broadcasting Services, OBS, is a company established by the IOC, which is responsible for producing the content with national broadcasters and media organizations such as the BBC, as we know, and here in Trinidad and Tobago is CNC3, then paying considerable sums for the exclusive right to provide content in their own territories. Many innovative broadcasting technologies are being displayed in Tokyo 2021 for the first time. The OBS has joined Chinese tech giant Alibaba to develop innovative cloud platform which will allow international broadcasters to operate remotely. This will help to reduce COVID-associated risk by so it's just really interesting how much OBS and how much technology is going to play in the Olympic Games. Which leads me to my second to last question, guys. Um, did COVID-19 affect the intellectual property of the Olympic Games?
Well, in a way, they did not allow it to, because if you notice, it's still all the branding for Tokyo 2020 is still being used, even though we're now in 2021. So after spending all that money on the 2020 Tokyo branding, I guess the decision was taken that they cannot redo it all because it would be such a huge cost. So it affected it in the sense that we're not exactly in alignment with the actual year it's being held in. But on the other hand, they went strong with what they had and they just said, well, it's Tokyo 2020, but we're having it in 2021. Justin, I don't know if you want to expand on that.
Yeah, I mean, the other issue that we're seeing at how COVID, I mean, arguably has, I would say, not affected the games, or rather has affected the games, is that despite COVID and despite many calls in many quarters to have the games abandoned, that's not an option, because let's think about the amount of investment and the amount of money put into these games. You have sponsors who would have paid up, 200 plus million to be involved as title sponsors. That money's already gone into the Olympics, and it's already, probably been dispersed in different avenues across the planet. So, if they chose not to have the games, then, where does this leave the sponsors? Then we talk about broadcasting rights. All of the different entities in the various regions and the various countries would have paid their license fees to get exclusive access to the broadcast rights. If the games don't take place, then you have a breach of contract arising, and then they have to have some sort of remuneration coming up. Whether it's, is that a credit passed on to the next event? Is it a case where, you get back your money? And this applies for both sponsors and broadcasters. You also just have the situation where a lot of money would have been invested in the intellectual property, as Dr. Perot said, branding the games. So COVID, yes, has impacted the games by, making it an entire year later. But I guess because of the fact of the value of the IP involved, it makes it very, very difficult to cancel the Olympics, among other reasons. So while I would say that COVID has impacted the games, I don't think it has impacted the IP. And arguably, we may say that the IP is actually one of the driving reasons as to why the Olympics has to take place and still happen.
So last question as we wrap up this episode 61, the law on the Olympics. What is the future of IP, intellectual property, in the Olympics?
I think IP is only going to increase in value in the Olympics because every time we have a new Olympics and we get new people watching, the broadcast rights and the value for that can increase. The value of exclusive sponsorship deals can only increase, especially with the role of social media. And when we think of the changes to Rule 40, when Rule 40 was first inactive, social media, it wasn't a thing in 1991. But now we are in this digital landscape where we have to go with the times, and IP is the most valuable asset of the Olympics. And I think they have realized that they are trying to strike more of a balance to allow the athletes themselves to benefit. But we can see that they're still very, very protective. And I think that's only going to continue in terms of the measures that are put in place to ensure that this value continues to grow. Because as Justin just mentioned, one of the real driving factors for the games even going ahead, despite uncertainty surrounding COVID at present, is because of all the investment. So it's not really the concern about the loss of the ticket sales, for example, or even the individual athletes, who of course I feel very sorry for after they train their lives for this. It's because all the money has already been spent on the IP, and that money has to be accounted for. So I think that is only going to continue to be more important as we move forward.
Anything from you, Justin?
Yeah, I mean, what I want to say is that I think the way that we perceive the Olympics and mega events going forward may change. And again, this has heavy emphasis on the nature of IP. So while we've been talking broadcasting, I think in the near future, we're not going to be talking broadcasting per se. We'll be talking streaming more, where it's being displayed online. We may also see a difference in the way that we interact with the games. You might get a more interactive environment, and this is where now technology is going to play an increasing part, and different elements of technology going to come into effect, like patterns, etc., where I'm pretty sure persons are going to start working or already are working on more interactive forms of telecommunication, so that persons at home can feel more involved in the event taking place, more on the field. And we're already seeing it in football, where there are different camera angles, different types of cameras being used. For example, if you watch La Liga football, when players score a goal and they're celebrating, the cameras actually get in the huddle almost. And the viewer seems as though they're experiencing the goal celebration in a more point of view dynamic. So we're going to see different techniques being used, different technologies coming into play, all of which have IP involved. So the perception of the games going forward, or any mega event going forward, I think is going to be different. And that's really part of the future of idea. And also just to say that and reiterate that without intellectual property, none of these sporting events exist. None of it is financially viable, and therefore IP is really the mainstay of sports, or rather we should say the mainstay of commercial sports.
What a way to end it. With that being said, I want to say thank you very much to Dr. Emma Perot and Dr. Justin Koo, who actually, ladies and gents, make up Clover Consultancy, who offers expert intellectual property information to individuals and business, as well as the creative, media, entertainment, and sports sector. So rest assured that Futsal868 is going to be a client. For those who want to, get more information on them, feel free to contact them, and it is there at www.clovertt.com. That's www.clovertt.com. Dr. Koo, Dr. Peru, you want to share some more light on this and find so persons can find more about you guys?
Sure. So we provide specialist intellectual property information and management services. Both myself and Dr. Koo, we have PhDs and LLMs in intellectual property. So we are uniquely positioned to give this type of information. We do things like contract drafting and assessment, trademark registration, dispute advice, and general consultancy, which would include things like auditing to determine what are your intellectual property assets, should you be registering, what steps do you need to take to really increase this alternative revenue stream. So you can go to www.clovertt.com to find out about all our services. We also will be launching a social media campaign soon, and you can find us on Instagram at Clover_IP. And hopefully we will be having content leading up to the Olympics. Of course, not benefiting from it, but providing an educational look at the role of IP.
And you will definitely be able to join Futsal868 as we define our intellectual property with Clover TT and the partnership that will exist. So I want to say thank you very much, Dr. Peru, as well as Dr. Koo. We wish you all continued success in all that you do. And once again, it has been a pleasure for you all to grace our virtual studios. Have a great one.
Thank you.
Thanks,
So that was Dr. Justin Koo as well as Dr. Emma Peru, who showed us, described for us, broke it down. Intellectual property, the new Olympic Games. That's Law and Sport, episode 61. Can you imagine it's episode 61 already? Next week, noting that the Olympics will have already started, we speak anti-doping with Dr. Sasha Sutherland, Executive Director for the Caribbean Regional Anti-Doping Organization. Yes, people, all they want to find out more about this whole situation with the US athlete and her smoking of the green-like substance, right? We'll discuss it more with Dr. Sasha Sutherland next week, Sunday at 4 p.m. And we want to say thank you very much for joining us once again on another episode of Futsal868 Corner Talks. As we end, we join our friend, Olympian, Cleopatra Burrell, as she urges you all to join the challenge. the Futsal 868 Virtual Race Challenge that is. Please register and be a part of a great cause. Until next week, be blessed.
Hi everyone, I'm so happy to announce that the Cleopatra Burrell Foundation will be partnering with Futsal 868 on their virtual race challenge to stop violence against women.